Welcome to this panel on defending press freedom in the New World Order. My name is Pádraig Hughes. I'm the legal director at Media Defence, and I'm delighted to be joined by three experts who are really working at the vanguard of defending press freedom in their respective roles as litigators and as policymakers. Andrea, Cairola, who's the advisor for communication and information at the Section for Freedom of Expression and Safety of Journalists at UNESCO and the coordinator of the UN Plan of Action on Safety of Journalists. Professor Yeğinsu is a barrister, international lawyer, who currently serves as deputy chair of the high-level panel of legal experts on media freedom, and he acts for a number of high-profile journalists and media outlets in litigation before international courts. And Martha Spurrier is a human rights barrister, campaigner, and policy expert at Doughty Street Chambers, and she specialises in civil liberties, international human rights, and equality cases. So I'm just going to say a few words before we get into it about the press freedom landscape, which I think we can all agree has been deteriorating quite dramatically in the last number of years. Journalists continue to be killed for their work at unprecedented rates in and out of armed conflict, and they continue to be arbitrarily detained in situations where they're denied access to lawyers, to medical assistance, and often denied access to contact with their family members. But there are new dimensions to how press freedom is being eroded that have developed in the last number of years and pose a grave threat to how journalists continue to carry out their work, bringing information into the public domain. SLAPS, for example, continues to be a huge issue, traditionally brought just in defamation. Now we see claimants, many of whom are state officials or they're linked to the state in some way, bringing claims based on the GDPR or GDPR equivalent legislation on the basis of breach of data or breach of privacy. Foreign agent laws are being introduced in many countries inspired by the Russian foreign agent laws. We've seen the Georgian foreign agent law, which was introduced recently, described as being Kremlin-inspired and being a facsimile of the Russian foreign agent law. And alongside those foreign agent laws, we're seeing laws designating organizations as undesirable being introduced as well. We've seen in some regions a lot of cybercrime law legislation being introduced, and it's notable in those countries, across different countries in some regions, you have that legislation containing provisions which are almost identical across different countries, which are imposing obligations on journalists using very vague, very overbroad language and criminalizing a lot of the type of journalistic work that would be considered routine. You have compulsory media registration making a comeback. You've got entry bans preventing journalists coming into countries, travel bans preventing journalists leaving countries, and then what we would consider to be perhaps one of the most serious threats in a long time to journalistic practice and integrity, which is the use of one-click spyware, which has been proliferating in recent years in different jurisdictions around the world. And there was an interesting decision coming out of California recently, or this week, in relation to that, secured by WhatsApp against the NSO group, which runs the Pegasus spyware, which may have a significant impact on the way in which that industry develops. So the one thing to note about all of these different levers that are being used by states is to recognize how opportunistic states are in the way in which they've embraced these different types of suppression of speech. Opportunistic, they've used innovation, they've been quite ingenious in the way in which they've adopted a lot of the kind of legal standards that have been developed in other jurisdictions where the rule of law is quite strong and where there are no significant systemic issues affecting the press, and use them against the press in their own countries under the guise that the press is engaged in some kind of practice to delegitimize or undermine the state. So taking all of these levers into account, we have for quite some time, for decades really, as journalists and lawyers, been relying on international courts, multilateral institutions to defend press freedom and to defend journalists. And the European Court, for example, has there's a judgment which kind of sums up the legal standard that states should apply to ensure that press freedom is protected, a positive obligation to create a favourable environment for participation in public debate, and a positive obligation to establish an effective system for protection of journalists. And we don't see that happening in many countries, and increasingly journalists are leaving places where they were previously one of the bulwarks against the way in which those authoritarian states operated. So against that rather grim backdrop, perhaps I can ask you, all of you, to maybe give your impressions on how you see this moment from a legal policy standpoint. Are we facing a crisis for press freedom and international law? And Chan, if I could start with you.
Sure. I mean, look, yes, we are. There has been a fundamental shift. There has been a fundamental shift in state conduct, state action, state inaction. There has been a fundamental shift in the sorts of issues that are arising. I think when you and I started, Pádraig, working together over a decade ago, states were in some regards less subtle. And now you see some very, very sophisticated attempts to suppress media freedom. And of course, that manifests itself in some of the cases that we are involved in as lawyers, unfortunately, as journalists. And it requires, I think you used the word ingenious. I think you're right in that characterization. And I also think it means that we also have to change the way in which we think and speak about the solutions to some of these challenges. Traditionally, we have formulated solutions by reference to domestic and international human rights. That is a very, very important area, and we should continue to focus, but we need to also look at other tools, other legal tools, other policy tools, and we need, in my view, to resist seeing media freedom as an island entire of itself, as a value in itself, as something that is being attacked by itself, because actually when you do the analysis, it is a key pillar to so much of what we call democracy, the rule of law, security, economic enlargement, and so on. So I think, what I want to kick off with is this idea that media freedom is very important and defending it is very important. And the challenges are indeed challenging, but that we must not look for the solutions only in one place.
Andrea, can I ask you about how policy has changed over the last number of years to meet the challenges that John was outlining?
Thank you, and first of all, thank you very much for the invitation to IPI. On one hand, we live in a moment where we have an unprecedented acquis in terms of international standards, international jurisprudence. This is, of course, in terms of global UN standards, in terms of regional standards, in terms of jurisprudence in the various regional courts, in terms also of stratification of UN resolutions, and that we say also in terms of awareness and of number of practitioners around the world. But on the other hand, as you rightly said, and also Chan complemented, we have huge challenges. We actually, to give a bit of some facts and to verify this perception from your side as practitioners, about the innovativeness, if I may say, the creativeness, not always for good. We actually had a survey jointly with High Commission of Human Rights, you also, your organization, you Defense, many other relevant organizations, with 800 judicial practitioners, lawyers all over the world. And out of this survey, actually, it's just confirming what you were saying in terms of that among all these respondents from about 100 countries, they perceived that 68% has been changing and being more aggressive in terms of legal tactics. SLAPPs, there's a lot of talk about SLAPPs, there are also a lot of resolution about that. Yes, SLAPPs, there's been an increase of almost 80%. And also, there is an increase of the misuse of financial charges. This is interesting and, of course, very challenging because this may translate into fines. So there's an economic impact on the production of media, which already strain, as we heard yesterday from Professor Stiglitz, in terms of their own viability. One of the consequences, of course, can be imprisonment. Other can be the loss of license. So it's not only touching on the journalist and the content production, but it's touching on the publisher, it's touching on the media outlet as a whole, and also as often the effect that it looks not related to the journalist profession, but looks like something that can impact also on the reputation, or I don't know, of the media manager or the publisher, or impact, of course, on the very existence of the media as a whole, and not on the individual media. So these are some initial, let's say, thoughts on that. We can further talk also about policies and of course, response, solution, resilience to this situation overall.
Thank you, Andrea. Martha, I think it's fair to say doctrinally, the standards, in a way, the standards have already been set by the various courts around the world in terms of media freedom. So there's a strong legal framework which lawyers can deploy in these circumstances. What do you think of this idea that lawyers are ending up engaging in essentially, rather than advancing the law, rather they're engaging in a type of law enforcement where they're acting in order to secure the rights that the international legal framework has already confirmed exist and they should be entitled to?
I think that's right, that lawyers are acting as law enforcements of existing standards, and also that we need something that takes us beyond, out of the courtroom, yep, and out of the rooms at which the policies are drafted, and into a space where a progressive narrative about the importance of media freedom and free speech becomes salient across the populations, in the EU and more broadly. In many countries around the world, and the UK is no exception, human rights as an idea are hugely under attack, and the legal frameworks that underpin them, the judges and lawyers that enforce them, are vilified. And, as has just been said, these rights, of course, are deeply interrelated, and we see the weaponization of free speech everywhere. Mm-hmm. We had an example recently in the UK where one of the kind of leaders of the far-right movement, a man who calls himself Tommy Robinson, was arrested at the border trying to get to France with £30,000 in cash and refused to hand over his phone on the basis that he has journalistic materials on there. Now, that may or may not be true, and a court of law at some point will determine that. But it's an indication of how far the idea of journalism, the idea of free speech, has been weaponized by extreme politics on the left and the right. And what is needed now, if we are not to just have to try and advocate for existing standards to be upheld or existing standards to be maintained and not eroded, is something much bolder and bigger that people can come behind, so that people truly understand what media freedom is and why it is so central to democracy, and therefore how we might go about defending it.
So, this brings me to the next question, which I know litigators and policymakers will be slightly reluctant to criticize the fora that they appear before, that they work with. But from a litigation perspective, Jan, I guess there are some concerns about the way in which courts are reacting to the circumstances that Martha has described, whether they're doing enough, whether they're recognizing the urgency of the situation, whether they take too minimalistic an approach when they're confronted with a set of circumstances where they can make a particularly useful intervention in the form of a judgment. What would you say in relation to the way the courts are addressing or confronting the issue?
I mean, let me answer that by reference to the international courts. Because, I don't disagree with the premise of the question, but also, when these frameworks were being established, there was a very clear understanding in the 1940s about how the system was going to operate. We're in Europe, so I'll take the European Court of Human Rights as an example. Many people, for understandable reasons, see it as a sort of appeal court. It's not an appeal court. It is also not a court of first instance, where you can go to and, ask for findings of fact, etc. The idea was that domestic courts would do their best. You would exhaust all of your remedies domestically, and then there was this fail-safe, which was supposed to police an international minimum standard of protection. Now, Pádraig, that is not what we're dealing with today. So these courts, these international organizations, whether it's the Council of Europe or the European Court of Human Rights, they probably receive applications in relation to one country that no court could cope with. And yet they have to deal with a great many countries. And they also need to respect in principle the idea that they are not a first instance court. And yet we all know that for many, many countries where there are media freedom issues, many journalists, many media organizations, many potential victims see that court in Strasbourg as their first and last recourse. And that is putting, obviously, the system under huge strain. It's putting the court in great difficulty. I've been talking at the level of concept. I want to give an example. Sure. Pádraig, you mentioned the foreign agents law in Russia, and many people in the room will know how that law also developed. Its scope started with NGOs, it grew to encapsulate media organizations and journalists, and then we had a new category of undesirables and so on and so forth. Now, my client, Radio Free Europe, Radio Liberty, challenged the legality of those laws before the Strasbourg court. And this is all in the public domain. It said to the European Court of Human Rights, please can you ask Russia to pause everything it's doing in Russia, pending the result of this judgment through interim relief, because if you do not, whatever judgment the court makes, we will have suffered irreparable harm, i.e. we will not be able to do our critical work in Russia. Now, the court didn't grant that interim relief, but the court said we're going to give this case priority, which means we'll deal with it really very quickly. Now, really very quickly for the Strasbourg court, it's a relative concept. And so we've ended up with a principled, very strong judgment from the Strasbourg court about foreign agents laws and how the Russian foreign agent law is unlawful. And we got that judgment around this time last year. But of course, there was no Radio Free Europe, Radio Liberty left in Russia. And of course, Russia had been kicked out of the Council of Europe as well in the interim. So this is a bit of an extreme example, but it I think gives you a fair answer to your question, which is the courts never anticipated being in this position. And I think it's fair to say that we are relying increasingly on the courts for recourse, and that is putting a lot of pressure on them. But I agree with your premise.
Yeah. I think it was similar with eco-defense.
Yes.
It took so long
Yes.
for eco-defense to come out that people were exceptionally angry with the court and the time it had taken. Andrea, can I ask you about the multilateral institutions, UNESCO and so on, how recent political developments have affected your ability to carry out your work in this sphere?
Yes, I think I will start again from what has been achieved. We are 14 years since the approval, the creation of the UN Plan of Action on Safety of Journalists and the issue of impunity. It was really a collective effort. It was not a plan of the UN. It was a plan that was developed with many of the stakeholders that are here in the room, the civil society, the representative from the journalists, the media employers, and of course the member states. And this plan has achieved quite a lot in terms of capacity to coordinate. There are several coalitions, the CSO coalition, the coalition of member states, forum for judicial, but also, concretely speaking, if we see, for instance, the plan is calling for creation of national mechanism of protection of journalists, and their UNESCO Global Repository on this has now listed over 50 of such mechanisms. In terms of the impunity, impunity is extremely high, too high, but over the time span of the implementation of the plan has been decreasing from 96 to 84 percentage point, 84%, so actually over 12 percentage point. So there is a lot of work, a lot of energy that has been put by the entire community into this. And I think in time where, as we all know, there is a crisis in terms of the rule of law, this has been mentioned, a crisis in terms of the viability of media, of course, the legal aspect also of that. I think it's very important that we maintain, let's say, this key. We keep on working together as community in our respective roles in that sense. And from our perspective of a UN specialized agency on freedom of expression and safety of journalists, we will keep on, of course, supporting that and also advocating for the new eras. For instance, we are just a few days ahead of the International Day to End Impunity for crimes against journalists, 2nd of November. Is a commemoration proclaimed by the UN General Assembly, and this year the topic is something that has been discussed also by the previous panelists in relation to the increased tech-facilitated online harassment of journalists, disproportionately also towards women, tech-facilitated gender-based violence, GBV. So we need to, of course, talk about that. Let's chat about GBV as well on the occasion of the 2nd of November.
Absolutely. Martha, I know you're on the Jimmy Lai legal team. In the context of, I mean, regional courts, I'm not sure if the UN Working Group on Arbitrary Detention has had any role in international institutions. Could you maybe say a little bit about the involvement in relation to those proceedings as they've been going on for a number of years?
So I'm part of the team representing Jimmy Lai, and his son Sebastian is actually here in the audience. For those who don't know, Jimmy is a 77-year-old man, a British citizen, who is currently in prison in Hong Kong. He's been in prison since December 2020, and he has faced trumped-up charges, politically motivated prosecution for being a journalist, for engaging with human rights defenders about human rights and with politicians about democracy. If he's convicted, and we are currently awaiting the verdict in his trial, then he may face a maximum sentence of life imprisonment. So this is a real life and death case, and Sebastian and others are doing everything that they can, as you can imagine, to try and bring him home to the UK before it's too late. I think it's a good example as a case of why those multilateral instruments are important, but also why they are the last refuge of the damned. Because we have a very strong opinion from the UN Working Group on Arbitrary Detention that Jimmy Lai is arbitrarily detained, that he should never have been arrested, should never have been charged, should never have been prosecuted, and should be immediately and unconditionally released. And we have had good interventions from a number of the different UN special procedures. Probably the most powerful that you could wish for in a case like this. But is Jimmy Lai at home in London with his granddaughter now? No, Jimmy Lai is in solitary confinement in a concrete cell in Hong Kong. And so this case, I think, really symbolises, firstly, that, as Jan has said, those multilateral instruments were never meant to have the teeth, the muscularity of domestic proceedings, that they go hand in hand with diplomacy and geopolitics, and that you need all of those things to be moving in the right direction in order to achieve a resolution in difficult cases like Jimmy's. At a time when those geopolitics are particularly fraught and the world order is particularly out of balance, those cases get even harder to resolve, regardless of how much support you're getting from the UN and other places.
Jan, do you want to come in on this?
Just very shortly, because I agree with absolutely everything there, and the reality is in these difficult cases, and I've just had experience of leading the team in the case of Alaa Abdel Fattah, who was detained for 6 years in Egypt. You know, one thing is not enough. So we didn't say the UN working group is hopeless. And I know you also went to the UN working group. We got a very, very strong opinion, of course. It also shouldn't require very big, high-profile legal teams to get this recourse, but the reality is that a lot of these mechanisms, it sometimes does matter who represents you, and it should not be like that. But in today's world, in these sorts of difficult cases, states, you need to be talking to states, you need to be resorting to any legal mechanism that you have access to. It's a journalistic campaign, it's trying to be very creative legally. You know, if we can't find a forum, can we do something that no one has done before? But when you take a step back, it should not require this much effort. It should not take 6 years for Alaa to have been released. What was his crime? He retweeted, but it was on Facebook, a post. And that was it. And there was no pretense. And, these are symbolic cases. And from my perspective, Martha, I think that there is actually a positive obligation on some states that say that they are democracies or are committed to democracy to not only look in their own backyard, but to really grapple with these sorts of difficult cases, these sorts of, no doubt, economically inconvenient cases, because if they don't, then it's very, very difficult to make progress.
Yeah, thank you for that. And just on the idea of creativity and trying to advance these types of situations, Media Defence has been representing scores of journalists in a particular country before the UN Working Group on arbitrary detention, and we would receive the opinions from the working group, very strong opinions, very, very well set out, and initially always referencing the fact that if what the state was doing continued, it would amount to a crime against humanity. Yeah. And we thought to ourselves, well, this gives us some indication of where the working group is going. Perhaps we can get some kind of universal jurisdiction case out of this. But then it stopped saying that, and it started saying serious international crimes. But I think they've already said too much, if that makes sense. And of course, in that kind of circumstance, Media Defence, a small NGO in London, you really do need this kind of weight of assistance from big law firms, policymakers, states. I think it's quite important that states are involved. For that kind of case, you're really relying on states or state institutions in any case. But in relation to this kind of litigation, Martha, maybe you have some views on accountability mechanisms, whether we're utilising all of the ones that are available to us, whether we could do more, whether we could go to different fora to try to litigate or advance the cases of these journalists who have been detained, or journalists who are facing threats in any kind of way, as I outlined at the very start. Yeah,
I mean, I think, as Jan said, I think the kind of creative legal ideas are always really important, not least because just by being novel and creative, they create a wave in themselves. And so I think there are definitely other mechanisms that can be exhausted. And I think that starts at home, right? I mean, there is a line of cases about positive obligations on states towards people facing the death penalty.
Yeah.
And when a citizen of your country is detained in a place where they may face the death penalty, what are the positive obligations on that state to bring that person home? And I think, speaking about the European Convention on Human Rights, there are, of course, as you talked about at the beginning, positive obligations under Article 10, but I think they probably are underdeveloped, and I think we probably could think more creatively about how to make them more robust and muscular. The challenge, of course, will then be getting them enforced effectively, and that's always the challenge whenever you have, even in things like torture and unlawful death cases, you have a suite of positive obligations that are nevertheless very difficult to get enforced. But I do think it would be a good start. And I think it can also be paired with thinking about how to strengthen press freedom in other ways. There are rights under Article 10 of access to information, for example, which could be interesting tools in the fight against misinformation, which in turn I think is part of what you need for a holistic defense of press freedom. So I definitely think that there are more legal tools that can and should be used, and they have to be used in a politically astute way so that you are leveraging the politics at the same time as leveraging the law, particularly when in many of these courts, either because they're under so much pressure or because the politics is unfavourable, there is a chill wind blowing through them on human rights cases.
Yeah. Just to talk a little bit about perhaps the collaboration and the future and what that would look like. How do you think, Andrea, journalists, institutions like UNESCO, lawyers, this kind of ecosystem of people who are working in this area could collaborate more effectively? I think the SLAP research that's I think it's being published today, more or less. That's a good example of bringing together all of these different interests who are being affected by this phenomenon, and essentially identifying all of the key issues and the things that need to be done. How do you think that can be done in relation to other threats to the media?
I think also connecting to what just said in terms of the accountability mechanism. The accountability mechanisms, of course, are there, and their functioning, their effectiveness is very much connected to the participation of the various actors. So if we talk about, for instance, national regional courts, it's a matter of capacity of lawyers, capacity of the judiciary. We run a judge training project that has been supporting the capacity building of judges at regional level and national level. Is always important. Also the interoperability, let's say, the exchange in jurisprudence in that is being supporting the prosecutors. But in this food chain, as you rightly said, fundamental, let's say, pillars of these are, of course, the journalists themselves and the lawyers. We have to also acknowledge and give the spotlight to the fact that one of the findings of this study is that the lawyers themselves are increasingly assaulted, are increasingly attacked because they do defend the media lawyers. They do actually are engaged in defending the media. So in some way, the issue of safety of journalists has been now shifted also to an issue of safety of lawyers defending journalists. So I think there is a need really to, of course, have this, let's say, wider holistic approach while we work for safety of journalists. There is the need also to support, of course, lawyers, because one of the findings is also the lack of capacity, the lack of resources, on top, of course, of the fear sometimes to defend, to get engaged in media cases. So we need to, of course, support lawyers, media lawyers network in that. And also we need to support the journalists themselves, of course, in we say about the importance of prevention. So, of course, in collaborating with the lawyers before to prevent, to a certain extent, as much as possible. But unfortunately, as we heard, this is not always possible because, of course, there is an intention to harm, which is beyond any possible, let's say, prevention as per due diligence. So then I think it's in terms of this collaboration between lawyers and journalists, I think is also very important that the journalists themselves are also empowered to cover all the food chain that brings this accountability, because they, of course, are referred as the watchdog democratic process. I think it's very important also that in this, let's say, perfect storm and combined crisis in terms of trust towards rule of law institution and towards the media, their watchdog role is also in putting the spotlight on these other crises that unfortunately goes hands in hands, and of course has a kind of vicious circle effect.
Yeah, I couldn't agree more. I mean, the lawyers and the journalists now, it seems it's hand in hand when they're defending journalists in difficult situations. Some of our cases at the European Court, just as we were filing the first ones, one of the lawyers we were working with in the country was arrested, had all his electronic devices seized, and was placed under arrest, house arrest for quite a while, on the basis, we suspect, of his involvement in the case. Martha, in relation to Jimmy Lai's case, I'm sure that the issue has come up around the way in which the lawyers have been pressured, if I can put it like that.
Yeah, so we, like I say, I'm part of the international legal team that operates out of London, but Jimmy has a legal defence team in Hong Kong. He was meant, in fact, to have a British barrister defend him. That person was then refused allowed to represent him. And we have, if you'll forgive what is not meant to be a pun, but sounds like a pun, a Chinese wall between ourselves and the team representing Jimmy, in part because they are under enormous pressure domestically. And as we understand it, the legal system in Hong Kong now, as it is in so many of these places that tend towards the authoritarian, is corrupted, and that fair trials in Hong Kong now are a thing of the past, and that the rule of law is not respected. And that's evident from the Jimmy Lai case itself, where, for example, it was widely reported that a witness was subjected to torture before giving his testimony. That testimony was heard in court. There has been no accountability whatsoever to the authorities for having used that evidence or undertaken that torture. So it's not recognisably a rule of law compliant process. It's not recognisably a fair trial. The verdict won't be a fair one. And there was never any pretense from the beginning that that's what this was going to be. So although, unlike in some other places, like Saudi, where most of these cases will be heard in camera, Jimmy's case is open to the world. You can go and you can watch what's happening, but that is a fig leaf of transparency that belies the unfairness underlying it. And yes, like I say, I think the lawyers domestically are under enormous pressure, and the lawyers internationally working on the case have, received some pressure and threats themselves as well. I mean, it's nothing compared, obviously, to what Jimmy and his family are going through, but it contributes to a wider climate of hostility towards anyone who is standing up for the people that are doing this important work.
Jan, do you want to add something to that?
Well, no, I was going to deal with the holistic, but I mean, I also have experience personally, whether it's in the country of my birth, Turkey, it is very, very difficult to be a lawyer in certain cases, because even if you feel fine, they'll go after your family. This is becoming an increasing problem. I mean, Maria Ressa likes to use the statistic when she's addressing lawyers, saying, yes, I got in trouble, I'm in the Philippines, they're really targeting journalists. But did you know that more lawyers have been killed in the Philippines in the last 5 years than journalists? And they are being targeted because of the work that they are doing. So this is a huge problem. This is a huge problem, and it is becoming very, very difficult to find lawyers in jurisdictions who are willing to take cases. I mean, you must find this in media defense. It's becoming increasingly difficult, and it's becoming increasingly difficult for any lawyers willing to take those cases to remain in country, because they will also be designated an undesirable, a foreign agent, or whatever it is, just because they're doing their job.
I can think of one country where every single lever has been used and the bar has been decimated to the extent that there's hardly any But there are some lawyers still
Yes.
who continue to work amazingly.
Pádraig, can I just instill some hope? Just by reference to the question you posed to Andrea. Just on we were talking about how lawyers and how journalists can work together, etc. So we just talked about the UN Working Group on Arbitrary Detention, and someone said that, I think it was Andrea, we have to anticipate issues. There's obviously this conference, there's been a lot of doom and gloom for obvious reasons in terms of where we are in media freedom, democracy, and so on. However, you were talking about the development of language at the UN Working Group around whether arbitrary detention could be elevated to a crime against humanity. Canada, 4 years ago, started a multi-state initiative, Canadian initiative on preventing arbitrary detention in state-to-state relations. Started with trying to think about how we can combat hostage-taking. Now, I think it's fair to say that that initiative has grown, the scope of that initiative has grown wider, and it now has over 70 states that have signed on to that. They have a panel of legal experts that's going to publish this month, or maybe early next month, a report that deals with the enforceability gap, especially at the UN Working Group on Arbitrary Detention. And it's going to be a very interesting report, bridging that enforceability gap. And now you've got these 70 states that have signed on to this, encouraging them to do something at the state level, whether it's as a matter of customary international law, or whether it's a matter of new lawmaking, to start giving teeth to opinions from the UN Working Group. Another example, the Media Freedom Coalition was set up in 2019. We had a meeting yesterday. UNESCO is a key partner. This is a block of states. They have a panel of legal experts on media freedom, and they have NGOs in the consultative network. We, as the high-level panel, designated safe refuge as a priority in 2021. We came up with a report which had recommendations, one of which was to ask these Media Freedom Coalition states to establish an emergency visa for journalists at risk. Took a lot of time, not only to draft the report and the recommendations, but some of the states established this visa. So when Russia invaded Ukraine, or when Russian journalists were designated foreign agents and had to move quickly, there was an emergency visa that Czechia had already had in place before the invasion, right? So I think as lawyers, and we have at least 3 on this panel, the cases are really important. That's what we've been trained to do, but also anticipating some of these gaps in the framework and trying to get states to fill it before the risk eventuates. And I hope that just gives an idea of the framework that we have at the moment. It's not perfect. There's still things we can do within that framework to make journalists safer.
I was asked to inject a note of positivity. I think you've done that, so thank you. We have 10 minutes left, yep. So we'll take questions from the floor.
Thank you for letting me.
Hello, my name is Anant. I'm from India. I am the president of India's Editors Guild. One of the problems we face is the criminalization of the entire legal system against journalists. And in India, we don't have absolute freedom of speech. There are laws which allow the government or somebody to file a criminal case against you for obscenity, morality, public order, incitement of violence between 2 communities. Then there is sedition law, and there is terrorism laws, and there's criminal defamation. Very often these laws are used against journalists for just reporting. A complaint is filed against them in a police station. The police station converts them into a report of cognizable offense. Prima facie, there's an offense. The journalist may be arrested. Sometimes they're arrested for many, many months or years. Often they may not be arrested, but the case starts on, wherein their personal presence and, of course, legal resources are required to defend them. The conviction rate is actually very, very low, maybe low single-digit percentage, but the process becomes a punishment.
Yeah.
So one of the questions or one of the demands that we have put forth is because journalists, just the matter of fact of reporting can be used as an instance filing a complaint against them by an agent which has been usually mandated by the government, because it's the government which has a problem with them. Can there be a layer of exception or an exemption, or rather not even an exemption, where before these cases are filed into or converted or complaints are made into a cognizable offense, there is a much higher level of scrutiny? And this also includes to search and seizure of devices. There is a case that we have filed in the Supreme Court where we've asked the government to issue guidelines when journalists or devices are taken, then what are the guidelines for those devices? So I'm asking, at the UNESCO level or at a multilateral organization, can there be some universal declaration that when complaints are filed against journalists in pursuit or in response to their work, there should be certain set of guidelines that any legal system, any criminal legal system should follow, before which the prosecution becomes, because seldom are journalists actually convicted. The process is the punishment.
I mean, that's a story as old as the problems that we're all facing in our work with journalists. We'll go to this one and then we'll...
Tamar Genzurashvili, I'm from Georgia. I represent organization targeted by foreign agent law. So my question is that I agree with Jan that Strasbourg Court is a hope for us, but if Human Rights Court fails to deliver justice timely and they are not using interim measure to save us, but we are not talking about just one law, there are a lot of legislative pieces and it's difficult to predict new repressive law. How we could prevent further distribution and spread of foreign agent law in other regions, and we see these trends within the EU. We call this law as a Russian, they call this US, and it's literally translated from FARA, but the targets are different, and they are using this against domestic democratic institutions. Thank you.
I'll just take the two and then I'll come to you. Martha, I wonder if you wanted to take
do you want to with your...
the first one?
I think, combining the two, I think interesting what was saying in terms of the process became the punishment. This is exactly, I don't know the specific context, of course, but this is exactly what is happening everywhere in the world, I would say, in terms of the increased number of slaps. Because this is exactly... So what to do anti-slap? We need an anti-slap strategy. So that has to be awareness. This is what we are doing, and also for, of course, data-based awareness also. And then there is the issue of monitoring. It's very important. There are, among these national mechanisms of protection of journalists I mentioned around the world, there are several that are actually monitoring the situation, including in terms of the disproportionate, the unduly use of this kind of tactics based on different sort of laws or strategies, etc. And then there are also some countries that have already successfully implemented, in terms of remedy, anti-slap laws. So this is something, Media Defense has been on the forefront of advocating for that, as well as the high-level legal panel. This part of, let's say, the combined response. So it's just like initial thoughts on that.
Thank you. Do you want to?
Yeah, very happy to. So just very quickly on, so in fact, I know from my involvement with UNESCO and my capacity high-level panel, there is a lot of training of prosecutors that UNESCO undertakes where there are clear guidelines as to heightened standards when it comes to the exercise of prosecutorial discretion. But of course, the problem is some of this, if you've got a good actor prosecutor, that training is extremely helpful and it's necessary, it's fundamental. But sometimes, and often, more often than not, you don't have the good actor. Look, this is not going to make me very popular with the Georgian government, but it's quite clear that for Georgia, the Achilles heel beyond human rights is economics. Whatever alliance the Georgian government wants to make with other states, whether it's Russia or Russia adjacent, Georgia needs foreign direct investment. Georgia is asking for foreign direct investment. Georgia has entered into many bilateral and multilateral investment treaties. There is an inherent tension between, on the one hand, saying, please bring your foreign capital to Georgia, and on the other saying that we're going to criminalize foreign capital?
Martha?
I just wanted to come in on the question that you were raising about the situation in India, and I agree with everything that's been said about heightened standards. I think there's also two other things it's worth thinking about. One is going back to the point about creative litigation. Many of the laws that you are talking about are, as you know, very overbroad colonial era laws that took a long time to get off the statute books in places like England, but are still on the statute books in places like India. And the strategies for getting them off the statute books in England were to rely on other human rights, things like privacy, and to show that those laws were unconstitutional. And of course those laws are used to persecute minoritized people, whether it's journalists or whether it's gay people or whatever. So I think one of the things is to do a kind of almost like a due diligence on existing legislation, and to go back to the very basics of how the root of that legislation might be challenged on a constitutional and human rights basis, so as to stop its abuse going forward. And then the second point is a prospective one, which is that time and again, wherever you are in the world, it's very easy to forget that the drafting of legislation is absolutely critical in how it will come to be enforced. And the example that's often used in the UK context is counter-terror legislation, which pretty much every year is used in a way that probably wasn't in the mind of people drafting it at the time, but has the effect of criminalising protesters or journalists or whatever. And so I think there is a piece of policy work to be done, whether that's by the third sector or by friendly politicians, to make sure that any legislation going through, that you are always doing a kind of hygiene test, going to the worst case scenario, to make sure that it can't be used and manipulated in ways not imagined at the time against people who are standing up to power.
And there was one more question.
So this afternoon we were discussing also, I attended a session about impunity, and it was regarding to the situation in Gaza. And I was, to be honest, expecting something more concrete, and you are the experts in this sense, most probably. Is it really realistic to expect ending impunity when it comes to the cases regarding press freedom and, of course, in Gaza case, death of journalists? You know, is it realistic? Is there such a mechanism, system in the world that would really end impunity?
It's the biggest
Yes. Well, I mean, there's certainly not going to be one instrument, I think, that ends impunity. We're working on something, I mean, beyond Gaza, obviously, but we're working on something within the Media Freedom Coalition. It's got some state support. I wouldn't put it higher than that. But this has been a huge problem for 30 years, at least. The statistics have not gotten better. They've gotten worse. But that doesn't mean we don't stop trying.
I think we'll end it on that note. So thank you very much.
Thank you.